Mr. Huizenga, 5 minutes.
Thank you, Madam Chair, and frankly, I hope there's another 14 hearings because this is one of the most expansive steps that government has taken. And I'm sorry my colleague is leaving. It just seems to me I'm not quite sure how I understand whether the CFPB is a five-member board versus a single individual, how exactly that is going to ensure the President's reelection or non-reelection. So I think that we're seeing obviously some heated rhetoric, and I've seen some positive elements on my bill specifically H.R. 3871. We've had everybody, Credit Union Association, National Association, Consumer Bankers Association, just recently both put letters in. Appreciate your support. The resounding endorsement of Professor Wilmarth. I think that one sentence I don't oppose. I'll take that as well. And I know that there has been some concern. I think somebody earlier had expressed that all three bills really chip away at the CFPB. And I just want to make sure that my colleagues aren't more concerned about keeping out any amendment to Dodd-Frank versus trying to make sure that we make it workable and do the right thing, which is exactly what House Bill 3871 is trying to do. And frankly, I'm happy to entertain the notion of belt and suspenders approach to amending both the CFPB Act and the FDI Act. But it seems to me that, as I think I can't remember, I'm sorry, it was Mr. Steinberg, I think, had noted on page 4 of your testimony. I had it up here at one point, but maybe you can comment a little bit on that, sort of the background of why we do need to not just do this with FDI and the deposit insurance side of things, but why we need to amend the CFPB and why maybe we shouldn't be so deathly afraid of changing a sentence or a jot or tittle in this. It is not holy writ that has come down from the heavens. This is the work of very fallible men and women who coming here trying to do the right thing, but let's try to make sure that it's workable. So if you care to comment.
I think that the oversight that Congress has shown about CFPB, I think also highlights the problems that some of the industry has with it, and certainly we do. We have never had a bill that is quite as large, that the scope is basically unlimited as we do with this piece of legislation. It is, they can act right now within the confines, as the ranking member has pointed out, initially in a very finite way, which might be a good direction, but that doesn't necessarily mean that the act itself, as drafted, as written, is basically carte blanche to do anything in this area that might impact consumers in any way for their financial services. So when we look at the act, we look at trying to put a little bit of belts and suspenders around it, a little bit somewhat insurance. When we asked our members at a recent meeting if they could rank the biggest concerns they had, it's always the uncertainty. And the uncertainty is because not of what CFPB has done, but what it could do. And all of these acts and the provisions we're talking about today really is a way to bring some oversight, to bring some accountability, so not because of what they've done, but what is so wide open in the future.
Sorry, thank you. And just so we're clear, my bill 3871 you view as one of those elements to provide clarity.
Absolutely. Yes,
okay.
An essential element.
All right, Mr. Wilmarth or Professor Wilmarth.
Well, I just wanted to point out that I think that Mr. Steinberg was probably referring to the so-called UDAP authority, but I've described at some length, and I can describe it if the committee wishes. There are very tight limitations and very specific findings that have to be made before the Bureau can issue a UDAP rule, and also a very detailed cost-benefit analysis. They've got to consult with federal prudential regulators. FSOC has a potential veto. So I don't think this authority is nearly as wide open as that statement might suggest. Thank you.
But you certainly don't see a problem with us providing that clarity.
Oh, no, I think the idea about providing that privileged materials, the privilege is maintained when institutions share them with their regulator, that to me seems perfectly sensible.
I appreciate that, and I think that to my colleagues on both sides of the aisle, I know we're having much broader conversations about whether the CFPB should or shouldn't exist, whether Dodd-Frank was good or bad, all those other things. But the simple fact is there is a hole, in my opinion, and in the opinion of virtually everybody who deals with this, that has to be fixed. So let's go do it. Let's go prove to the American people that we can set aside bickering and go get something done that is going to protect the consumer and protect those that are serving the consumer. So I appreciate that. And my last little quick reminder, I mean, we're seeing a lot of heated rhetoric, and I just want to remind everybody we're in the same boat. Banking lenders, non-banking lenders, you name it. I mean, there's a lot of stuff that's getting thrown out there, and I just caution everybody to make sure that you realize we're trying to all be on the same team here to make sure that we are protecting consumers and also protecting business people, men and women who are in this industry who are providing that service. So thank you very much, Madam Chair.
Thank you. Mr. Hinojosa for